All right, good morning. So welcome to class. As I mentioned earlier, I have a personal engagement on Monday, October 17th. So we'll be meeting remotely. The plan is today for us to go through about 24 or so pages of the book. So through to page 284. We'll see if we run out of time to do that, and we'll have a proportionately lighter load on Wednesday. As I mentioned earlier, on Wednesday we'll have first a Thrive presentation, which is about 15 minutes, and then we'll have our usual weekly presentation, and then we'll get into the rest of the material for this week. So we're still under the doctrine of consideration. You'll recall we saw just about all of it before reading week. We said that a contract to be enforceable has to have not only offer and acceptance, but also consideration. So we spent quite a lot of time in this class looking at the requirements for offer and acceptance, how they have to match, and how you can have various complications of offer and acceptance. For example, when a contract is made through the mail, or when you have conflicting terms that go back and forth between the parties. On top of that, you have to have consideration, so you have to have a benefit that's provided essentially in a way that's mutual. So there has to be something given up or that benefits both parties. And so, for example, if someone's selling a car, right, then the car, on the one hand, is the benefit, and the money that the other party gets in return is the benefit that they get. We run into problems where we have what we call gratuitous or empty promises, which is when there's only one party that benefits. So something similar to a gift, we'll see a variation of that today with what we call charitable subscriptions, but basically something that's given with nothing in return, and therefore the contract would be void for lack of consideration. So we're still under consideration, looking at the last few issues having to do with consideration. Specifically, we're still under what we call pre-existing obligations. So we looked at a number of cases last week or the week before the reading week that considered the performance of an obligation under an existing contract. And we said that as a default rule, right, a commitment to do something, although that something is, right, of value or would otherwise count, is not consideration under a new contract because you already have an obligation to do it. And so there's no benefit to the counterparty in you doing that because you're already obligated to do it under the existing contract. And therefore that commitment or that action, if it is actually done, does not constitute consideration to create a new contract. We'll see that that rule has been significantly watered down by courts in very recent years. The first case that you have in the readings for this week at page 260 is the Nav Canada case v. Greater Fredericton Airport Authority, Inc., is the case where the court, you'll notice it's an appellate court, so it's not the Supreme Court, but it's still a principle that was consistently applied in subsequent cases in other provinces. So it's good law as though it were decided by the Supreme Court of Canada and is binding essentially throughout the country. And it's recent, right? It's a case from 2008, and we'll see that's been clarified in an even more recent case from 2011. You have a unanimous court, it's mentioned at the very beginning, right? So 3 judges generally at the Court of Appeal, having to do with, again, the enforceability of a variation to an existing contract, which is just a different way to say a pre-existing legal obligation. So there's already an obligation to do something under an existing contract, and then the parties try to change that existing contract. Well, to the extent that, right, it's not a mutual change. So, for example, we saw a case where one party just agrees to pay more money. Well, then it's not mutual, right? So the other party's doing what they're already obligated to do. So, for example, they provide material for a house, but then to get paid more money to do that. It's not, right, a contract that has consideration because there's only one party that's providing a benefit, and therefore it would be void. So that's the default rule, right? In that case, you have a change to an airport runway, and essentially NAV Canada insists upon a specific piece of equipment being used in that change or renovation of a runway. And we find that, right, it was actually entitled to do that under the contract. Nonetheless, there was a dispute as to who would pay for that. NAV Canada said it would not pay for it. And the result of the dispute was that the airport authority, so the other party, ended up agreeing to pay for that piece of equipment. And they specifically provided that it was done, right, under protest. So they basically said, we do not think that we have an obligation to pay for this, but we'll pay for it anyway, right? Because otherwise the runway is not going to get done and we'll paralyze the entire airport, and it's not worth it for us to fight over this, but we'll try to kind of reserve our rights under the contract if there's a subsequent legal dispute before the courts. So as it turns out, right, court finds that the airport authority was not contractually obliged to pay for that because NAV Canada had the right to insist upon the specific piece of equipment being used, and therefore had to pay for it because that's what the contract provided. Nonetheless, right, you have a subsequent agreement that looks a lot like a pre-existing legal obligation, right? We find that NAV Canada had an obligation, again, to pay for that piece of equipment. It is not a contested term. We'll see that that becomes relevant in future cases if there's uncertainty as to the actual interpretation of the contract or the legal obligation that's being invoked. Then it gets a bit trickier and in fact might constitute consideration. It's not the case here, right? You're told that there's no, you're not told, rather, that there is disagreement as to the interpretation of the contract. And NAV Canada, right, would have had to pay for this, but there's an agreement to the effect that the airport authority will instead pay for that. Well, under the principles that we saw, this is clearly void for lack of consideration, because they only did, right, what they otherwise would have an obligation to do, and then they decide there's a subsequent agreement that says they won't have to do it, and there's consideration for that in the form of the payment of money, right? Well, NAV Canada has not provided anything of value because, right, it already had to pay, then it doesn't have to pay, so it's provided something, but doesn't provide anything in exchange. So it's a modification of the existing contract, and it's not supported by consideration, because one party pays, and there's no benefit in return. The court, as we'll see, varies the rule quite significantly. So you'll recall we had seen some exceptions to that rule, right, to the rule that a pre-existing legal obligation is not sufficient. The main exception that we saw was when there was uncertainty as to performance, and the court stresses at page 262 that's not the case in every case. So you don't have, quote unquote, a right not to perform under the contract. You don't have a right to threaten not to perform what you otherwise have an obligation to perform pursuant to the contract. So if you just say, I'm not going to respect my existing contractual obligation, that uncertainty, although it may exist, is not sufficient to constitute consideration for a modification of the contract. And again, a modification of the contract is just a different way to say, right, a new contract. So a new contract on top of the old one that happens to change the old one. So a subsequent contract. So if there's uncertainty, though, for a legitimate reason as to performance, and we saw the test in a far more detailed way In the Rafi Brothers case, the test is actually, as I mentioned 2 weeks ago, at page 260 at the very top, right? There's a number of steps, 6, and that provides for a way when there's a legitimate uncertainty. So one party is going to go bankrupt, for example, and therefore they just won't be able to do the work that they've been contracted to do. Then the removal of that uncertainty can constitute consideration. So they decide to do it anyway, and then in exchange for that, they get additional money, right? Doing it anyway, which is their pre-existing legal obligation, can constitute consideration because there was uncertainty as to whether or not they would actually perform, and it was for a legitimate reason, right? So they were going to go bankrupt, or right, they just didn't have enough money to pay for the materials that they had to use. They didn't just wake up one morning and say, we're going to renege on the contract, which again would not in itself be sufficient. So the court, right, reviews these principles. In doing that, stresses something that we mentioned earlier but did not see in that much detail, and that is that estoppel cannot be used as a sword, can only be used as a shield. This is not particularly important for our purposes, especially not at this stage of the course, but it can be helpful for you to understand kind of the broad strokes of that. So, estoppel is an equity doctrine. So we saw the distinction between law and equity. I won't get into that again, but it developed as a doctrine that could provide for an unfair application of the law. So when the law as applied as stated by the courts would have an unfair result, a result that's not consistent with justice, equity comes in and saves the parties by providing for an exception and saying that the law is not going to apply. One of these, right, one of the ways in which it applies is with part performance. We mentioned that briefly. We'll see that in a lot more detail. So when the parties perform on a contract that's otherwise invalid, it can still be enforced under equity, although it's not, again, legally valid. So it doesn't meet the regular legal requirements offer acceptance consideration. Nonetheless, it might be enforced under equity, although it's not valid in law. Another aspect of that of equity that applies to contract law is detrimental reliance. So when there's a promise that's not binding, for example, a gratuitous promise, so someone says, I will give you money, and then there's detrimental reliance upon that promise, and the parameters have to be pretty specific, as we'll see for the charitable subscriptions cases. I'm just giving that as a general example. There's reliance on that promise that's not in itself enforceable. It can be enforceable to some extent. Usually what that will mean is that it will be enforceable for the purposes of compensating for that loss, but not enforcing the whole promise. So not right the whole donation or whatever was promised, simply compensating the party for the damages that they've incurred in reliance, if that reliance was reasonable, and there's a few further requirements. So all that to say, reliance is a way for equity to essentially enforce an otherwise unenforceable promise. But it can only be claimed, generally, by the defendant. In other words, by the person being sued. So if someone says, right, this contract is not valid, I want my money or my thing back, well, then you can say you have waived your right to do that by part performance or reliance or whatever. So it's a defense to the claim that's being made. What it cannot do is be used by a plaintiff to enforce a contract against a counterparty. So you can't go to court and say, I want the whole agreement, the whole promise to be enforceable because of what we call promissory estoppel, because of equity, and try to get something from the other party because you're in the position of the plaintiff. Again, it's not all that important, but it's mentioned a number of times in the case, And that will become, right, significantly clearer as we look at, right, the actual doctrines of equity later on in this course. So because of that, right, in this case, it cannot be claimed and relied upon as a doctrine. That's mentioned at page 282. The court notes at the top of the 262, sorry. Court notes at the top of page 263, right, some of the ways in which prior courts have gotten around the strictures of the doctrine of consideration, some of which, or most of which, we saw in our readings before the reading week. So first, when there's an additional, right, commitment, then it's valid. So if you agree to do more than you did under the contract, and because the courts, again, don't look at the adequacy or the size of the consideration, it can be pretty limited. So you can agree to do a little bit more and get a lot more money in exchange. And again, right, peppercorn, all what we saw, because the court doesn't look at the adequacy of consideration, it will be sufficient to ground that contractual modification and make it legally valid. Second, when the circumstances have changed, I'm quoting directly now, after the contract was formed, that's what we discussed earlier, when there's uncertainty as to the performance of the contract for legitimate reasons. Detrimental reliance is the third one, and the fourth one is to think that the contract has been rescinded. So one of the things that the party can do is rescind the existing contract, right? So you have to mutually agree to enter into a contract. Well, you can also mutually agree to get out of the contract. If there's only one party that does that, it's called a contractual breach. But if it's both parties, they can mutually rescind the contract and then come up with a new one. So we'll see it's a bit clumsy, right? You don't usually want to do that because there's lots of consequences, right? It gets rid of all the obligations under the contract. Also, there's no guarantee that the party subsequently will enter into the contract that you thought they would enter into instead. But again, that's one of the ways in which the courts have been able to get somewhat away from the strictures of the doctrine of consideration. Okay, there's a mention of the Ruffy Brothers case. I mentioned that earlier. That's the case where you have the pretty detailed test at the top of page 260, which we saw 2 weeks ago. But basically, when there's uncertainty as to the performance of the contract, that is the second sub-step, right? So the first one is there's a contract. Second one is B, which is a counterparty, could be either, has a reason to doubt whether A will or will be able to complete his side of the bargain. Third sub-step, right, thereupon, as a result, in other words, promises an additional payment so that they will honor their existing contractual obligation, and therefore they save themselves from that uncertainty. Then it is valid unless there is economic duress. So that's the test that's provided for, and the court in the case we're looking at, the Nav Canada case, significantly relaxes that, at least on the face of the text of the decision, by saying basically a modification to the contract. In fact, getting rid of most of the steps, at least on the face of the decision, will be enforceable unless there's economic duress. So gets rid of the most of the relevance of the doctrine of consideration in that specific context, and says it will be presumptively valid. Otherwise, rate would not be, because there's only a unilateral promise. There's no consideration unless there's economic duress. We'll see that get slightly more complicated as we go. The economic duress part of this, right, it goes back to the very first cases that we saw under the doctrine of consideration. So you'll recall the Salmon cases, right, where they would take advantage of a change in circumstances, right? So everyone's going to die, and then they say, we're going to desert the ship. Well, it's not fair, right? Because first, they already have an obligation to do that, right? In other words, it's a risky job. They know what they're signing up for, and therefore, right, when it gets risky or deadly, they have to stay on. Well, they can't take advantage of that exigent circumstance to try to get more money to do their existing job. The nominal reason for that is that there's no consideration, is that you're promising to do what they're already obligated to do and trying to get more money to do it. That's a lack of consideration. It's not valid under the law. However, the courts, as we said, have moved away from that strict application of consideration and provided for many exceptions. And the way in which they've done that is by evaluating the underlying policy rationale for that decision and saying that what we're trying to prevent in the Salmon cases is economic duress. It's when someone is trying to take advantage of exigent circumstances to get more money for a pre-existing legal obligation. And you see that reflected here, right? The court has basically two underlying policy rationales for what it's deciding to do. It's saying, first, it's frustrating the legitimate expectations of the party. We saw that multiple times, right? That contract law, at least to some extent, is supposed to reflect the legitimate expectations of generally business people and enforce the contracts that they would normally expect to be enforceable with rules or requirements that they would normally expect to apply in their specific circumstances. It's one of the policy rationales. The second one is, right, the lack of economic duress. So when you mutually agree on a modification to an existing contract, and there's nothing to suggest that it's not fair or that you've taken advantage of an undue threat. So you said, I'll breach, or I'll use all my money to sue you, or you won't get any money from me because I'll move my assets elsewhere. Supposed to, I won't have actual money, which might be a consideration under the Ruffey Brothers case. The court says, again, if there's no economic duress, it will be presumptively valid. And the court says that that's an incremental, quote unquote, right? That's a consistent magic word in how judges legitimate their decisions under the common law. It's an incremental change to the common law, which judges are supposed to do, right? So they can't just, out of nowhere, for example, under tort law, right, come up with a principle that says you have to be reasonably careful in your interactions with other people, right? It's not their job. Their job is to decide specific cases, and they can't just create a general obligation out of thin air. However, they can eventually do that incrementally, right? So if now they've imposed 20 different legal obligations to be careful in specific situations, right? So your neighbors or people who interact with you at work, right? Whatever. And then these obligations apply in a lot of contexts. They can say, well, it might well be because it turns out that you have a general obligation to do that, to be reasonably careful all of the time. And the court legitimates that evolution of the common law by saying we're only moving incrementally and meeting the commercial expectations of the parties. That does not, you're mentioned at page 265 and of the case, fully displace the default rule. In other words, if you have consideration, it will be helpful. It will be helpful because, first, it will show consent. So, again, the underlying reason for the doctrine of consideration is because we want to enforce promises that are mutually beneficial. The kind of promises that people reasonably expect to be enforced by the law. Well, if we're doing that, right, we affect that intent by requiring consideration, a mutual benefit, not a unilateral one. Well, if you have consideration for a contractual modification, it will help show consent and therefore also offer an acceptance meaning of the minds, all the things that we saw. And on top of that, will arguably, that's me, it's not the court saying that, but arguably also remove some uncertainty. So you won't have to go to court and start pleading whether or not there's economic duress, which is, at the end of the day, somewhat subjective. If there's consideration, it's presumptively valid. You don't have to argue over that and fall under the exception, which again is a pretty broad one that changes the default rule as well. Then you have the 2011 case I mentioned earlier, Riverwind versus British Columbia. Again, decision from an appellate court in British Columbia for the same reasons applies everywhere. And the court essentially, I won't go over it in that much detail, but imposes an additional requirement that otherwise did not apply. So it requires that there be reliance or a benefit on top of what I mentioned earlier. So there has to be, right, a benefit to either party or detrimental reliance on top of the criteria that I mentioned earlier. Okay, so moving further away from that, pretty significant, as I mentioned, modification to the application of the doctrine of consideration to pre-existing legal obligations or modifications to existing contracts, right? Both of these, again, are pretty much the same thing. You have another case having to do with uncertainty, and this is something that directly relates to the case that we saw before, the reading week. So there's one case that's repeatedly cited, which is the Gilbert Steele case, which you'll recall was this case where the parties agreed for the provision of something, some end product having to do with steel. Doesn't really matter specifically what it was. Then the price of steel changes, and the counterparty tries to get more money to perform their existing obligation to provide something derives from the steel, basically. Again, the facts are not particularly important. What's important is that both parties agreed to pay more money for the same thing, the same end product. And the court says, although they've agreed, although it's in writing, right, it's consensual, offer acceptance, all that, it is not valid because there is no consideration, because they only did what they were already obliged to do. That's in contrast to, again, the Ruffy Brothers case, where there was something else. There was also not just paying more money for the same thing, there was also reasonable, legitimate uncertainty as to whether the contract would be performed, because they would not be able to complete the houses in time for the amount of money that was provided for, and therefore, it was legitimate that they agreed to get more money to do what they were already required to do. And the court reiterates that principle in the Richcraft Holmes case at page 266. There's basically uncertainty as to the interpretation of a contractual clause, and the parties create a new contract. Again, new contract or modification to the existing one is pretty much the same thing, to provide for that uncertainty, to avoid it. And the court says that that's valid because there's a benefit. The benefit is to both parties, and it is to avoid that contractual uncertainty. Okay, following case that you have, line of cases actually, has to do with the payment of money and the modalities of that payment of money when there's a pre-existing obligation to pay that amount of money. So again, you pay it fast, or you pay it in installments, or the counterparty gets out of the uncertainty of you going bankrupt or not paying by you entering into a payment plan, essentially. First case you have is Folks v. Beer, again, very old, so pretty significantly different from the line of cases we just saw, which were recent and Canadian. This is back to the 1800s and the House of Lords. And basically there's an existing judgment, so one party owes the other party an amount of money pursuant to a judgment, which is just like a contract, pre-existing legal obligation. They have to pay. And then instead of paying that amount with interest, which they would have to pay interest if they waited over time to pay that amount, they enter into a payment plan where the counterparty basically gives up their right to require the payment of interest in exchange for the debt. The court says that that's not in itself valid when we apply the strictures of the doctrine of consideration, because it's the pre-existing obligation, right? They already had the obligation to pay back the money with interest, and now they're getting a unilateral benefit. They're getting more time to do what they're already obliged to do, which is the same thing as saying you'll get more money to do what you're already obliged to do. And the court says that that's not valid, presumptively. However, that's been changed quite directly in more recent cases. And essentially now, that is a benefit if there's, again, that uncertainty that we discussed earlier. So if it's unclear whether or not the counterparty will pay, right, if they might fall into bankruptcy, there's a general presumption that getting paid over time, which might mean getting paid faster under different modalities, will be enforceable. So essentially the opposite of what we just mentioned has been ruled upon by the courts. So that's it for the section on consideration. I will interrupt the video, and then there will be a new one on the next section, which is on compromises.